Hello, good morning. Today's topic of discussion is establishment of Supreme Court or creation of Supreme Court as per the provision of Regulating Act and Charter of 1774. So let's discuss establishment of Supreme Court. Regulating Act provided for the creation of the Supreme Court at Calcutta. In the furtherance or in the continuance of the provisions of the Regulating Act, the Charter was issued by the King George III in the year 1774. It provided for the establishment of the Supreme Court at Calcutta. This provision was specially made to remove the defective state of the judiciary as it existed under the Charter of 1753. The Act provided for the establishment of Crown's Court in the form of the Supreme Court at Calcutta. So, the Charter appointed the first Chief Justice and judges of the Supreme Court. Sir Elijah Impey was appointed as the first Chief Justice along with three other peon or companion judges. Peon judges means Kanishta. A composition of Supreme Court. A Supreme Court consisting of a Chief Justice and three peon or companion judges. These judges were to be barristers of England or Ireland. The barristers of at least 5 years standing were eligible for the appointment as judges in the court. So these judges were to be barristers of not less than 5 years standing. The judges were to hold office during the pleasure of the Crown. The judges of the Supreme Court were also justices of peace. The Supreme Court was the court of record. Let's discuss the jurisdiction of the Supreme Court. The Act provided that all His Majesty's subjects, residents of Calcutta, Fort William, and Bengal, Bihar, and Orissa were placed directly under the jurisdiction of the Supreme Court. In other words, the jurisdiction of the court was regarding number one, British subjects in the province of Bengal, Bihar, and Orissa. B. Persons in the service of the company. And C. Voluntary submission by the natives to the jurisdiction of the Supreme Court. Supreme Court was conferred with the jurisdiction to try and decide number one, cases of civil nature. Civil nature cases means cases relating to will, trust, probate, disputes, land or property disputes, breach of contract, then the dispute relating to money or injury to personal rights, defamation, family law disputes, divorce, child custody. So these are the cases of civil nature. Then the criminal cases, admiralty cases, cases on high seas, piracies. So these were the admiralty cases. Then the ecclesiastical cases, that is religious matters. Then the testamentary jurisdiction. Testamentary jurisdiction means relating to will. A testament means a legal document declaring a person's wishes regarding the disposal of their property when he dies. Then the probate jurisdiction. Probate म्हणजेच मृत्यूपत्र खरे असल्याचा कोर्टाचा दावा. That means the copy of a will certified under the seal of a court jurisdiction, competent court jurisdiction. Then the appointment of the guardians for minors, appointment of caretakers for the persons of unsound mind. The court was empowered to try all civil actions and suits concerning trespass, injuries. Injuries means hani or damages or debt or concerning any house, land or other real means immovable property or personal property in Bengal, Bihar and Orissa brought against the East India Company. The court was also authorized to frame rules of practice for subordinate courts as were necessary for the administration of justice. Rules made were subject to the approval of the king in council. Next point is appeal from the decision of the Supreme Court. The decision of this court was final in the cases in civil matters if valuation of the subject matter was up to 1000 pagodas. So pagoda was the currency, Portuguese currency. If the valuation was more than 1000 pagodas, then a further appeal could be preferred to the King in Council, that is Privy Council in England, when within period of 6 months. So the period of limitation was also prescribed. In criminal cases, the Supreme Court had full discretion to allow or reject the petition seeking the permission to appeal. So if the appeal is allowed, in criminal cases, appeals from the Supreme Court could be filed before the King in Council in England. Ineligibility of the Supreme Court had no jurisdiction over the Governor General in Council. The court was declared ineligible to hear and determine any cases against the Governor General or any member of the Council in any case except treason म्हणजे राजद्रोह or felony म्हणजे महापातक किंवा घोर अपराध. The Governor General, member of the Council and the judges of the Supreme Court were immune, means they were free from the arrest or imprisonment at the hands of the Supreme Court. Means Supreme Court was not having jurisdiction over Governor General and member of his council and the judges of the Supreme Court. The laws to be applied by the Supreme Court, the laws made by the Governor General in Council, because Governor General in Council was empowered to make laws, means they were having legislative authority as per the Charter of 1753 that already we have discussed. Then the English law was also applied, the personal laws of Indians, that is when the parties were Hindu or Muslim, then their personal laws were applicable. And in the absence of any such provision, the principles of equity and good conscience was applied. Next, functioning or merits of the Supreme Court. It was the Crown's court because it was established as per the provision of Regulating Act. Number 2, it was the court of record and superseded the mayor's court. The mayor's courts were established as per the Charter of 1753. It was trial as well as appellate court, means it was having original as well as appellate jurisdiction. Number 4, this court could exercise jurisdiction in respect of all legal matters. Supreme Court could exercise common law or equity, almorality and ecclesiastical, that is religious jurisdictions. When all these various and distinct jurisdictions were combined to be discharged by one tribunal, and that was the Supreme Court. So number 5 was it was independent of the executive, because here the judges were trained in law and they were appointed as the judges of the Supreme Court. The persons who were well trained in law were appointed as the judges of the Supreme Court, and they were professional lawyers and appointed by His Majesty and could take impartial view in cases in which either the company or its servants happened to be involved, and therefore it was independent of the executive. Here Governor General and his council had no role to perform. Number 7, advocate were registered with the court and were allowed to practice before the courts. Number 8, the judges of the Supreme Court were empowered to issue prerogative writs. Writs means that is a prerogative order of the court you must be knowing the writs of prohibition, mandamus, certiorari, habeas corpus. These are the writs. In these way, this court came to be a much more efficient and effective instrument of justice than the mayor's court. So let's discuss the defect in the act. The regulating act suffered from following defects. Number one, it had no jurisdiction in revenue administration of justice. It had no jurisdiction in respect of the persons who were not British subjects or who were not Europeans or the natives who were not in the service of the company. The relationship between the Supreme Court and the Supreme Government was not well defined. The relationship between the company court and the Crown's court was not well defined under the Act. The judges of the courts were not well versed with the Indian situation as well as they were not aware of the Indian laws and the customs. The English judges not only applied the English law in India but also applied English criminal law in India. So, with this, I have completed the establishment of Supreme Court as per the provision of Regulating Act. Thank you.